All rise.
Open court.
Oyez, oyez. Silence is commanded for the justices of the Supreme Court of Kentucky while they are sitting. All those having pleas to make or causes to prosecute, draw nigh and you shall be heard. This court is now in session. God save the Commonwealth. God save this honorable court. You may be seated.
The case to be heard at this hour is J.N.R. et al. Versus Judge Joseph O'Reilly and others. For the appellants, Mr. Watermen, I believe you've requested 11 minutes with 4 for rebuttal. Is that correct?
Yes, Your Honor, that is correct.
Okay. And for the appellees, Mr. Helmers, you'll have 15 minutes. Mr. Watermen, you may proceed.
Thank you, Your Honor. Good morning, and may it please the Court. Mr. Helmer, Mr. Demuth, Mr. Ricketts. This is an appeal pursuant to Rule 36 of the Kentucky Rules of Civil Procedure. The broad issues before this Court this morning involve standing, the jurisdiction of the family court, Jefferson Circuit Court Family Division, of an individual, the appellee, to seek custody pursuant to Kentucky Revised Statutes Chapters 403 and 406 to a child born to an intact marriage. Secondly, is the presumption of legitimacy pursuant to KRS 406-011. And finally, perhaps most importantly, in my estimation, is the best interest of this child. The procedural history is brief in this case. The real party in interest, the appellee, filed a petition for custody and support on September 26, 2006, seeking custody pursuant to the aforementioned statutes. The appellant filed a motion to dismiss 1 month later on October 26th. Jefferson Family Court Division 7 ruled on that motion to dismiss and denied that motion to dismiss 1 month later on November 29th. We immediately the appellant filed a writ of prohibition to the Kentucky Court of Appeals on December 6th, 2006, along with an emergency motion to stay the proceedings at the appellate court. Pursuant to Justice Wine, 3 days later on December 8, 2006, those proceedings were stayed. On February 8, 2007, the Court of Appeals granted in part and denied in part the writ of prohibition. The court said there should be no mediation until paternity was established, but that they cannot reach the merits as they did not find a lack of remedy at law or a great injustice. We immediately appealed to this honorable court on March 6th, pursuant to an order issued by this court through Chief Justice Lambert on May 3rd. Again, the proceedings at the lower court were stayed. We suggest and argue today that the Court of Appeals was wrong, and we are seeking for this court to enter an order dismissing this cause of action or instructing Jefferson Circuit Court Family Division 7 to dismiss this cause of action. There are 2 classes of writs of prohibition, as this court well knows. One, where you're outside your jurisdiction and there's no remedy to an intermediate court. And secondly, where the lower court is within its jurisdiction but is wrong and irreparable injury or great harm will result. I suggest to this court that the appellee is outside the class of people who are allowed to bring a paternity case or a custody case, and therefore the jurisdiction for the lower court did not exist. Jurisdiction...
Counsel, surely a family court, a circuit court in Kentucky, has jurisdiction of issues of custody, paternity, and those sorts of things. Isn't the focus on whether the court has jurisdiction? You seem to be shifting the focus on, you seem to be making a standing argument rather than a jurisdiction of the court argument.
Yes, sir. I'm making both because I believe under Chief Justice, under the statute, the person can only address the court under two prongs. In this case, he brought the case under KRS 403 and said, I am a parent, which we believe he is not a parent by definition. And he brought the case under 406, which is our paternity statute, as the court well knows. And my argument to the court, in which I believe the law throughout this entire jurisdiction is, there is no illegitimate child here. This child was born under the presumption of KRS 406.011. This child was born to an intact marriage. That makes this child one of the strongest presumptions known to man, one of the strongest presumptions known in the law, and one of the most bedrock parts of our community is family, and the presumption that a child born to a marriage is a child of that marriage.
Where do you get your definition of parent? Where do you draw that?
Sir, I would start, Your Honor, from Black's Law Dictionary, which says that a parent is a father or mother of a person. In the case at bar, this person is not a parent. He is not, by law, defined as a parent. At best, Justice Scott, he could be a putative father in this situation.
What's your definition of father?
My definition of father...
I mean, do you have anything in the statute or any case law saying a father is not a biological? I mean, how do I know it's not biological parent versus parent by marriage?
I would have to do that, Justice Schroeder, in the negative. The direct answer to your question is no, there's nothing in the statute that says a father is. But if you look at cases, including the Supreme Court case, the United States Supreme Court case of Michael H. versus Gerald D., you see that what they say is that biology has to take a back seat to the definition of father, which is the parent, which is the person to whom the child is born in the marriage. You see that throughout an entire line of cases, Justice Schroeder, where if you look at the cases that we've cited in our brief, throughout the complete lineage of cases, for example, there's no one that would allege that the father or the biological putative father is a father per se. You have cases where child was conceived prior to the marriage. No standing for paternity or definition of being a father. You have cases where the child was conceived during a separation. No standing, no ability to bring a custody case. You have, even where you have a case where you have a divorce, the affair occurs, child is conceived, you have a remarriage, the child is born, still no ability, no definition as a father. And to the far extreme, you've got cases in this country where a new husband has an affair with wife conceives, but yet not yet divorced, child born, then new wife marries the new husband, old husband is still considered the father. It's the family, so I have to do it, Your Honor, in the negative.
Okay, but when you start talking about the rebuttable presumption, it's not an irrebuttable presumption under the statute, is it? I mean, if we don't have the typical family, or if we have these adjustments, isn't that why you have just a presumption instead of a legislative fiat saying this shall be so, it's irrebuttable?
I would address that in two ways, Justice Schroeder. I would say first and foremost, if the legislature had wanted to add inclusio, exclusio, if the legislature had wanted to include that class of person, it would have done so. The presumption, if you look at the case law, the dichotomy is that the presumption exists so that the parties to the marriage can attack it if they feel so. What we're trying to avoid here in the case at bar is allowing an outside interloper.
Counsel, let me see if I understand your position then. Are you saying that marriage is a complete bar to a biological parent's rights?
Yes, ma'am. Yes, Your Honor. I am suggesting that a child born to an intact marriage, which remains intact, does bar a putative biological person, a biological individual, from making a claim of paternity, because in my estimation, Your Honor, with all due respect, Justice Noble, I think it has to be done to protect the family in our society.
Did
Well-
not the United States Supreme Court in 1989 affirm that principle in Michael H.